Good afternoon, Senator Jackson.
Good afternoon, Assemblymember Wilk. My apologies. We were hearing a rather difficult bill on the genocide. I didn't want to get up and leave for fear of offending everybody as compared to just anybody. So,
well, you have two bills before us today, SB 142 and SB 570. So if you could start with 142, that'd be great.
Very happy to do so, and want to thank you, Chair and members. This measure, SB 142, would prohibit the use of unmanned aircraft systems, also known as drones, in the airspace above your property without your permission, something that I know members of your committee are equally as concerned about. Existing law protects the privacy of California residents in their homes, both by prohibiting others from entering onto their lands without permission, where one has a reasonable expectation of privacy. This bill clarifies how these long-standing principles of trespass and privacy apply to unmanned aircraft. California is a state that has made an extremely strong commitment to privacy. In the federal Constitution, the right of privacy is implicit. There is no statement that there is a right to privacy. It is implied within that Constitution. In California, the right of privacy is clearly articulated as one of the fundamental rights: life, liberty, property, privacy. So here in California, we have a very, very strong and constitutional protection to privacy. Now, we know that drones have a lot of potentially useful and extremely innovative purposes, but invading our privacy and property without permission or legal authority should not be among them. Just as I can't walk into your backyard without your permission, I shouldn't be able to fly my drone in your backyard while you're enjoying the outdoors with your family, or watching your kids playing on the swings or a little pool that you might have in your yard. Last week, a woman in Seattle was knocked unconscious when a 2-pound drone fell from the sky. This is not just an issue for homeowners, though. The proliferation of unmanned aerial vehicles has raised questions for the American Chemistry Council about potential security threats to critical infrastructure, such as chemical plants, refineries, and electricity-generating facilities. This bill, SB 142, clarifies and reinforces California's existing law on trespass in an important way. It clarifies that trespassing includes entry onto someone else's land with a drone. Okay. Usually that says time to be quiet. But what I just want to do is identify, too, that the bill recognizes a zone up to 350 feet above the ground where you, as a property owner, have the right to exclude drones that are operated in a manner that invades your privacy. It wouldn't affect what people do on their own land, like farmers using drones to monitor crop conditions, a very positive and helpful use of a drone, nor would it restrict what people can do on their own property, on public streets, or in public parks. It only addresses flying drones onto somebody else's land, into their backyard, without their permission. This measure is an important first step in creating a balance for the privacy concerns of Californians and the use of unmanned vehicles. And with that, I would respectfully ask for your aye vote.
Thank you so much. Others in support?
Samantha Corbin on behalf of Privacy Rights Clearinghouse in support of the measure. We appreciate what the author's doing here in terms of a first step. I know a lot of folks are anxiously awaiting, particularly some large retailers, the feds, to make decisions around regulations in this area. But I do think that it's appropriate for us as a state to set some minimum standards for homeowners and those who have private lands, and appreciate the author's effort. So we ask for your aye vote. Thank you.
Thank you, Mr. Chairman. Tom Sheehy with Greenberg Toreg, representing the California Police Chiefs Association, here in support today of Senator Hannah Beth Jackson's bill. I want to just say that Senator Jackson has been very responsive to the concerns that we had when this bill was in the House of Origin. She took the amendments that the Cal Chiefs were looking for to resolve their issues. We were very appreciative of that working relationship. I want to just finally say that we think that this bill strikes a good balance between the privacy needs and civil issues versus the need for law enforcement to be able to conduct lawful investigations. And we appreciate that balance in this bill, and we would respectfully ask for your aye vote today. Thank you.
Mr. Chairman, members of the committee, Randy Pollock on behalf of the American Chemistry Council. We're in support of this. As you know, our chemical plants, infrastructure in this country is very important. We want to make sure that they are properly secured. Over the past 10 years, we spent over $14 billion in security measures, and we believe that this is a very important bill to make sure that there's not sabotage or UAV could come over and drop into one of our facilities and harm our equipment. So we're in strong support. Thank you.
Sir, are you a tweener again? You want to go ahead and go to the mic, and then we'll do opponents if we have any.
Yes, I'm Bruce Parks with the Silicon Valley chapter of the AUVSI, and we have the concerns that we have rest with the ability of legislation to curtail the further development of the UAV industry, and that is going to be a very large industry in this state. And I have to also say that we have been working with Senator Jackson very amicably, and I appreciate the fact that we have been able to work with them. I don't think anybody here has the intention of passing legislation that would impede the growth of what we see as a very important economic boost to the state. We want to delineate the difference between a commercial operation and a and hobbyist, essentially. And we think that what the senator is most concerned with are the hobbyists. We don't represent that group of folks. What we are concerned with, again, is our ability to be able to grow the industry and fly these units commercially. Thank you.
Mr. Chairman, members of the committee, my name is Mario Morena. I am the Senior Government Relations Manager for the Association for Unmanned Vehicle Systems International. And I first want to thank Senator Jackson for introducing this piece of legislation, and we support her efforts. Our only concern is that it may have unintended consequences, as that Mr. Parks alluded to. We want to be a regulated industry. Just because we have a UAS platform does not necessarily mean that we can go up and fly a UAS arbitrarily. We have to go through the full regulatory process at the FAA of obtaining a certificate of authorization, where, when, how, and what we fly before we're actually able to gain access to the National Airspace System, providing we have a license. So our concern is that some of the altitudes listed in the legislation as it's currently written may be in conflict with some of the ongoing regulatory processes that are taking place at the federal level, primarily the small UAS rule that will hopefully be adjudicated by December of this year, probably as late as mid-June of next year. And more importantly, it may be in conflict with what's going on at the federal level. But as currently written, this legislation would practically eliminate commercial use for UAS operators, not only in California but across the country. Thank you for your time.
Any others in opposition?
My name is Gary Darling, and I'm speaking in opposition to this bill. I have a letter that's being passed out. There were a number of problems, but largely the big one is that if you raise all of those UASs from, now they fly at 100 feet or 200 feet, and bring them up close to the ceiling with civil aviation, you're going to exponentially increase the probability of some sort class of accident. This is particularly bad for firefighters who, in the last few weeks, even have had a couple of events where there have been near misses. If you create a zone that's right next to the bottom of civil aviation, that's the drone zone, the no liability zone, you're creating a situation that's quite unsafe. It's already something of a concern that we don't have a system that will let us know where there are fires, where there are endangered species that need to be protected. Where is our critical infrastructure, or rules that prevent us from flying over critical infrastructure? The second piece of this is that it really won't do much to help us with privacy. If you grab an iPhone and just go out in front of the Capitol, and it's 300 feet if you cross the street to that lawn, that's the 350-foot mark, and just zoom in, it's easy to see people's faces. A point-and-shoot camera can easily resolve what people look like, and if you take Photoshop and enhance it a little, you can tell whether or not their shoes are tied. You can do everything vertically with a drone that you can do with a point-and-shoot camera. It's just so easy to get around this the way it's written. It does so little to help privacy, but it does so much to endanger lives. Another piece of this that I think really needs some serious consideration is right now the information available to the public is largely wrong. And I challenge your staff to look in your own district, put in a Google term like no-fly zone or where can I fly drones, and terribly inaccurate maps will come up. One place you can look is Davis, California. You can't fly a drone anywhere in Davis because there's an airport at the university. But I can't find a website where that's marked. The Smithsonian, referenced here, has a website that misses the Davis Library, the Woodland, or the Davis Airport, the Woodland Airport, the CHP Academy. If you simply corrected the maps, you would eliminate from flight ability about where 1 million people live in the United States. It's just a matter of correcting the maps, working it through. The FAA is working on a website, but it's taking them a very long time. You can find that site, look at it, see what the proper map is, but it's not really publicly released without a complex beta site permission. So my sense is that we could fix this problem easily and cheaply by correcting the maps, by acknowledging those places where people have already expressed their preference not to have drones flown over their property, essentially posted no trespassing, and it would show up on the map and say to drone owners, don't fly here. We'd be able to protect our critical infrastructure.
Right.
Put temporary
Thank you, sir. You didn't give your name and organization before you started, so if you could do that for the record.
My name is Gary Darling. I'm here as a private individual.
Okay, great. Thank you so much. So, Senator, I don't know if you want to do rebuttal now or you want to mention that in your close, whatever you want to do, because I'm going to go to questions from the committee.
Sure, I'll just respond. That's not what this bill is all about. We already have constructive invasion of privacy that deals with the question of photography and so forth. This bill just says you can't fly a drone over somebody's property within 350 or less without their permission. It's a trespass law. So if we can focus it on that, with all due respect to this gentleman, I don't want to get into mapping here, mapping there. This just says you have the right to a reasonable expectation of privacy in your own home. And California, being a state that says privacy is a fundamental constitutional right, explicit in our Constitution, that's what this bill does. And the other information may be some other more esoteric view of the problem. But right now, and I might also mention that the FAA has specifically said that it will leave privacy issues to the states. And that's what we're dealing with here. So the feds will do their thing, perhaps at a higher level. We're taking 350 feet and saying, look, this is within the state's purview, which we believe it is, and we're going to protect individuals' rights in their own home to have that reasonable expectation of privacy.
Thank you, Senator. Questions from the committee. Mr. Daly.
Thank you, Mr. Chairman. I want to just thank you so much for bringing this bill forward. I'm a private landowner, and I know the laws of having to post my property so that you can actually, when somebody trespasses on your land, how you can then prosecute. It's very difficult in this state to prosecute somebody who has trespassed on your land and violated your private property rights. So I am in full support of your bill. I'm glad that you brought it forth. And just last Wednesday, Senator Gaines and I did town hall meetings up in Shasta County, and a gentleman at the town hall brought a photo of a drone sitting outside of his sliding glass window. He took a picture of it, and I said, and he asked me about what's going to happen, and I told him that we were going to see this bill coming forth in privacy. So I support your bill. I probably would have got my shotgun out and shot the thing out of the sky, and then probably would have been in some sort of trouble for that. But
the answer is yes, you would have been.
I know it, but there needs to be some boundaries. I think this is just a start, the first step in a long series of things that we're going to see with the drones. We know that they're great for agriculture. We use them, and for business, and they're appropriate for that reason. But for private property uses, I think this is a great step in the right direction. I look forward to voting yes on your bill.
Thank you, sir.
Mr. Gordon.
Yes, thank you, Senator. I know you said that federal government intends to leave the privacy issues to the state, but I think we're just months away from FAA standards. Would would it make sense for us to wait to see what the federal standards are before and then work within those around California standards?
Well, I think it would be helpful to the FAA if we sort of establish what we believe the appropriate level should be. And my understanding is that their discussion is 500 feet, maybe 400 feet, but there are precedents for the level that we have established within this bill at 350 feet, and there is an acknowledgement that federal jurisdiction, like in so many things, applies above a certain level, and that below a certain level, people actually have private property rights, and the state has jurisdiction within those levels. So I think that the FAA is not going to set a lower limit, but that this at 350 feet will provide them with the flexibility we anticipate that they're looking for. But also a statement, because they have indicated that they're going to leave privacy issues to the state, that we consider this to be amongst within that purview of the state and as part of our privacy protections within our Constitution.
Thank you.
Ms. Chang?
Senator, thank you so much for your bill. This, I know, will be very helpful regarding privacy. However, I do have a concern regarding the commercial use of drones and whether or not you believe your bill would impede on the commercial use of drones. I know that a lot of different companies are coming up with creative ideas to be able to drop off different packages and.
Sure. This is a bill that says that that I have a right with up to 350 feet of my home to be safe from any invasion of my privacy, any trespass of my property, any potential possibility that a drone will be flying within that level that could actually fall out of the sky. I don't believe you were here when I initially indicated that just a few days ago, a woman was knocked unconscious in her own backyard from a drone that crashed and hit her, I believe, in the head, causing her to become unconscious. So I suspect that there will be a discussion, that there are companies that would like to be able to provide packages to people. I do think, though, that it is incumbent upon us as the policymakers to basically set those parameters on behalf of the people we represent, on behalf of rights of privacy that we have, to be able to set the parameters around which those companies will operate. And that, I think, is, again, part of our responsibility. This bill takes into account the privacy right and expectation that we have within our own homes to be free of the kinds of invasions that can occur from trespass and that occur when something or person is in a place where they're not invited to be. And the analogy is to trespass the same way I can't jump my neighbor's fence and go into their backyard without their permission, but would then be violating the rights of trespass, the common law rights, the statutory rights that we have here in California. I would need their permission. Without that, I'm violating their rights. You mentioned the person who took a photo of a drone peering through their window. This is not an unheard of story. In fact, my original interest in this bill came when I was sitting in the backyard with some friends and my husband having a cup of coffee one morning, and a drone flew in and spent 2 or 3 minutes eyeball to eyeball with my husband, who didn't have a shotgun, or he might have taken it to him as well, and then to discover that there was no violation of law going on.
No, Ray, I'm completely with you on that point. It's just that I am concerned about commercial drones, and if we do advance to the point where, you have drones that would be dropping off packages, whether or not that would be protected.
I think at the point at which that discussion takes place that we should have a robust discussion about it. But this, again, is a bill that at this point in time says that you have a right of privacy within a space of 350 feet and below that is part of your home, if you will.
Right. Okay. Great. Thank you.
Yep.
Mr. DeBomne?
Yes, to the author, I just want to know, you mentioned that this would be good for guidelines that would help FAA. Have you had discussions with anyone at FAA? Are there any other kind of discussions going on with FAA between yourself or any other?
Not directly. I mean, we've been following what the FAA is looking at, and the 350-foot limit that we put is based upon what the FAA has historically viewed as local airspace versus federally controlled airspace.
And just to follow, have any other states already passed similar legislation around that foot level that have had time to be implemented yet or on that path?
I believe we have Oregon is one, Georgia, interesting enough, and another couple other states. New Mexico.
Thank you. I appreciate it.
Ms. Baker.
Thank you, and thank you for this bill. I'm going to support your bill today, and I haven't had the creepy experience that our colleagues have, but I see it coming. I do share the concerns of our good colleague, Ms. Chang, regarding commercial technology and dropping off packages. So I offer a comment. I can't remember, property law was a long time ago for me in law school, but, we have people deliver packages at your front door. And so it isn't without precedent that the purchase of an item is consent to entering your property to deliver it, potentially. So I don't think that's an insurmountable problem. I think we can look to what may be considered rudimentary delivery methods as guidance on that. So I do encourage us to just be mindful of the good points our fellow member has raised regarding that technology and the ability to deliver packages. I don't think it is without precedent that we're able to do it with consent on property. There's ways that people can allow others to come onto their property, especially when they've voluntarily purchased something. So I'm pleased to support your bill today and appreciate your interest in protecting privacy.
Thank you.
Mr. Cooper?
I want to thank you, Senator. It's a great bill. I think it's very practical with that, and I'll agree with Ms. Baker's comments. If you're a property owner and you're having a drone deliver something, you're not going to press charges. And anyways, if an issue happened, it would be the property owner's discretion whether they want to pursue that or not. And as far as the commercial drone folks, your drones are flying from point A to point B. They're not lording over someone's backyard, so I don't really see the issue with that. And someone's backyard is their own personal private property, and I do agree with that. So I think a lot of these issues, a lot of what-ifs, are not going to happen. But let's face it, there are voyeurs out there that are flying some of these drones around, and it is a real issue. So, like I said, if someone flies over my backyard, I'm okay with it, but keep going. Don't just stop and hover there. I'd have an issue with that. So I think your bill is very practical. It's a common sense approach, and it's catching up with the times.
I might indicate, too, in terms of delivering a package, I don't know about you, but if a delivery person opened my back door or came in through my yard, I'd be a little bit concerned. Usually they deliver them to the front door, and again, it's the practice, and it's something that I think we all feel comfortable with. And I look forward to those discussions going forward as these new technologies are developed. Right now, though, this bill is focused on this particular issue.
I'm going to call on me before I hand back the gavel to the chairman. Hey, I just want to thank you for this bill. I had a very similar situation on 4th of July. I'm at the fireworks show. I had a couple come up to me and complain about how they were sunbathing in their backyard and there was a drone watching them. So this is something we definitely need to address, and I just appreciate your leadership on that. And should I go ahead and finish it off, Mr. Chair? So
yeah, go ahead. Thank you.
If there's any other questions, the recommendation is do pass and send to approps. Judiciary, I'm sorry. So if the Secretary could call the roll.
Gatto.
Aye.
Gatto, aye. Wilk.
Aye.
Wilk, aye. Baker. Aye. Baker, aye. Calderon. Aye. Calderon, aye. Chang. Aye. Chang, aye. Chow. Chow, aye. Cooper. Aye. Cooper, aye. DeBobne. Aye. DeBobne, aye. Daly. Aye. Daly, aye. Gordon. Aye. Gordon, aye. Lowe.
All right, that bill has passed. We will hold the roll open for other members. I believe next you have Senate Bill 570.
Very good. I hope we treated you well over in Senate Judiciary.
Nobody was there. I did get 2 votes, though, but hopefully the rest of the people will go add on. So,
thank you. Thank you, Mr. Chair and members. This is SB 570 I present to you. This is a bill that would improve the readability of the notices sent to California residents whenever their personal information is thought to have been stolen in a data breach. In 2002, California enacted a first-in-the-nation security breach notification law, and since that time, all but 4 states have enacted similar laws. Unfortunately, we've needed those laws, and I'm here today because As we have progressed with information technology, we have also seen an increase in the theft of that information. But the notification under our breach law requires state agencies and businesses to notify individuals when their unencrypted personal information has been breached. This notification ensures that residents are made aware of the breach, allowing them to take appropriate action to mitigate or prevent potential financial losses due to fraudulent activity associated with that breach. Existing law requires breach notifications to be made in the most expedient time possible without unreasonable delay, and specifies certain information that must be included in these notices. The law provides that breach notifications must be written in plain language, but is otherwise silent about how that information should be presented or organized. Unfortunately, data breach notices are often written in ways that obscure the information they contain, making them less effective in communicating critical information to affected California residents. I can tell you that I'm a recovering lawyer as well, and I have had my data breached, and I've tried to read some of these notices and have to tell you in all honesty that some of them are absolutely incomprehensible to me. So the Attorney General's 2014 California Data Breach Report sort of confirms that, and I felt somewhat vindicated by that. But the report states that using the Fleisch-Kincaid grade level index to assess readability of 70 randomly selected notices, no significant improvement in readability has occurred since readability assessments began in 2012.
I will second the bill.
Bottom line is we need them more easily understandable and in a way so that people actually can try to know what's been taken and to try to do something about it. So this bill simply requires 5 specific headings: what happened, what information was involved, what we are doing, meaning the company whose information's been breached, what you can do, meaning what you can do as someone whose information has been breached, and then for more information, what you do then. It doesn't impose any new requirements to disclose additional information, and at that point I will stop and ask for your aye vote.
Wonderful. Let's go to your first witness in support.
I'm Joan McNabb, Director of Privacy Education and Policy in the Attorney General's Office. And as the Senator indicated, the basic idea for this is suggested in our breach reports that we do annually, almost annually. And the basic point is the notices, as they often exist now, are 3 to 5 pages long. It's hard to notice what it's about. It's hard to understand it once you've figured out that it's about something bad. And this bill would make them easier to understand, easier to recognize for what they are, and easier for people to do what they must do. And I urge your aye vote.
Thank you very much. Next witness.
Samantha Corbin on behalf of Privacy Rights Clearinghouse, also in support of the bill for all the reasons stated by both the author and the Attorney General's office. We receive hundreds upon hundreds of complaints and concerns from consumers on these type of issues on a regular basis over at PRC, and I'm hopeful that this will provide them with the tools necessary to take action when their information has been compromised. Thank you.
Terrific. Let's go to public comment in support. Any public comment in support? Yeah.
Mr. Chair, members, Jeremy Merz on behalf of the California Chamber of Commerce. We're in a tweener position. We have removed opposition and now are neutral on the bill. We'd like to thank committee staff and thank the author staff as well for the hard work they've put in.
Thank you.
Margaret Gladstein on behalf of the California Retailers Association. We too are neutral and appreciate working with the author and staff to resolve our concerns.
Courtney Jensen with the California Credit Union League, also in a neutral position, and want to thank the author and the staff.
Wants to join the party. Want to thank Senator Jackson, staff, and the Attorney General's office for the July 2nd version of the bill, and she's addressed all the concerns we had with the measure. Thank you.
Any witnesses in opposition? Seeing none. Public comment in opposition? Seeing none. Questions or comments from the panel? Ms. Baker.
Thank you, Mr. Chairman, and thank you, Senator, for taking those amendments. We've seen time and again both at the federal and the state level, the attempts to make things more clear in disclosures, and then the micromanagement becomes unwieldy and we have problems. So I applaud you for being willing to really distill it down to what can be most clear at this stage, and appreciate that. And I've moved my no to a yes, so glad to support your bill.
Thank you.
Any other questions or comments? Would you like to close?
Just briefly, I appreciated the opportunity to work with industry. We have taken the suggested amendments. The amendments eliminated a page limitation contained in an earlier version. We wanted it all, if we could, on a single page so it's easily readable. It will hopefully still be easily readable, but gives a little more flexibility. It doesn't change the rules on what you have to provide. It just makes it clearer as to how those who have been affected, and I suspect we all have by data breaches, that we will be able to at least understand what's happened and have some idea of what we can do to rectify the problem with the information provided. So with that, I would ask for your aye vote.
Wonderful. Madam Secretary, please call the roll.
The motion is due pass to appropriations. Gatto?
Aye.
Gatto, aye. Wilk?
Aye.
Wilk, aye. Baker? Aye. Baker, aye. Calderon? Aye. Calderon, aye. Chang? Chow? Aye. Chow, aye. Cooper?
Aye.
Cooper, aye. DeBobne? Aye. DeBobne, aye. Daly? Daly, aye. Gordon? Aye. Gordon, aye. Lowe?
That bill has passed. We will hold the roll open.
Thank you, Mr.
Thank you
Chair,
very much.
members.
All right. I see Senator Pan, who's been patiently waiting. Welcome. You have Senate Bill 573, the statewide open data portal. The floor is yours.
Thank you. Thank you, Mr. Chair, members. SB All right. Well, SB 573 increases access to state-collected data for public use, which will improve transparency and accountability, increase efficiency, cost savings across all state agencies, and foster innovative economic development. We're going to create a robust statewide open data portal to publicize and centralize data sets in collaboration with state agencies with support from an appointed state chief data officer. And with that, since it's already been moved, I'll respectfully ask for an aye vote. And I thought I had a witness here. But, there we
All right, let's go to your witnesses. Oh, and you've taken the amendments, just for the record?
Yes.
Okay.
Accepting the amendments being proposed by the committee. Thank you.
Terrific. And let's go to your first witness.
Hello, my name is Jesse Romine, and I'm with a company called Socrata. First of all, I'd like to thank Chairman Gatto and the committee members for the opportunity to discuss this important legislation. In addition, I'd like to thank Dr. Pan for the leadership role that he's taken on this important issue, as well as his staff. And finally, I'd like to thank those in the civic community, organizations, and industry for the interest and support in SB 573. When done properly, state-level open data programs result in tremendous benefits both internally and externally. Internal benefits include data collaboration, operational efficiencies, data-driven decision-making, sunsetting of legacy systems, and overall collaboration. External benefits such as access, understanding, collaboration with government, as well as economic opportunities that Dr. Pan spoke to a moment ago, are what really get me excited. In fact, 132 companies on the Open Data 500 list, which is a list an organization called GovLab produces, are based in the state of California. Now, SB 573 provides very detailed definitions, but at a high level, the word open can be considered accessible. The word data can be considered information without context. Now, to some, this equates to transparency, and that's absolutely part of this. But really, it's about information sharing, collaboration, data-driven decision-making, generating economic opportunities, and driving innovation. And I'd like to commend Dr. Pan for taking a leadership role on this important matter, and I congratulate this.
Great. Any other witnesses in support?
Mr. Chair and members, Christopher Castrillo on behalf of Los Angeles Mayor Eric Garcetti. Just want to echo the previous comments and urge your support of the bill. Thank you.
All right. Public comment and support.
Brandon Roberts here on behalf of the Health Officers Association of California. We're in support.
Samantha Corbett on behalf of Electronic Frontier Foundation, late to the party, but in support of the measure. Thank you.
Witnesses in opposition, public comment in opposition, members of the panel. Seeing none, would you like to close?
Respectfully ask for an aye vote supported by diverse coalition with no formal opposition. Thank you.
Terrific. Madam Secretary.
The motion is due pass as amended to appropriations. Gatto?
Aye.
Gatto, aye. Wilk?
Aye.
Wilk, aye. Baker?
Aye.
Baker, aye. Calderon? Yep. Calderon, aye. Chang? Chow? Chow, aye. Cooper? Aye. Cooper, aye. DeBobne? Aye. DeBobne, aye. Daly? Aye. Daly, aye. Gordon? Aye. Gordon, aye. Lowe? Aye. Lowe, aye.
That bill is passed.
Thank you.
All right, we're going to now go through the whole agenda real quick so members can add on. Yeah, I got to move fast though. I got to do it. Okay, we'll do add-ons up at the front here.